Today, the Supreme Court of the United States heard oral arguments in U.S. versus 𝗬𝗓𝗏, a case brought by the Biden administration on behalf of families of trans youth to challenge the constitutionality of Tennessee's gender-affirming care ban, also known as SB 1. The Tennessee law restricts puberty blockers and hormone therapy for trans minors and creates civil penalties for doctors. The court is considering the arguments today and likely won't issue a ruling until June, but people are watching closely as fully half of the country, at least 25 states, have gender-affirming care bans of some kind in place, and this ruling would affect whether or not a number of those laws can stay on the books and create precedent for further challenges. UCLA attorney Chase Strangio is appearing on behalf of the families before the court today, the first openly trans attorney who's ever argued before the court. And he went to my law school, not to brag. Today we're going to talk about the details of U.S. versus 𝗬𝗏𝗧 and how the outcome of this case could impact trans people and their families nationwide, as well as the uncertain future of the case and for trans folks everywhere as Trump takes the White House in January. Let's get into it. Thank you to my partner on today's video, Surfshark. Surfshark is a VPN that keeps your online identity safe by encrypting all of the information sent between your device and the internet. This keeps your personal data protected from big companies or cyber criminals. Also, a VPN swaps the real location of your device with a new one, also known as changing your IP address, and this way you can virtually travel to any country around the globe, allowing you to unblock streaming platforms and get different content libraries from around the world. It also gives you greater online capabilities so you can access your favorite websites from back home, even when you're traveling. And I don't know about you, but those targeted ads are getting really creepy. And with Surfshark, your browsing data is private, so that shoe you looked at 2 weeks ago won't be haunting you all over the internet. Plus, if you use public Wi-Fi networks at airports or coffee shops, Surfshark protects your privacy and encrypts your online data from hackers. And Surfshark works on multiple devices, so you can be sure you're protected on your desktop, laptop, phone, and more. Take control of your online security with Surfshark today. Surfshark offers a 30-day money-back guarantee, so there's no risk to give it a try. Head to surfshark.com/Leeja or click the link in the description now for 4 extra months of Surfshark at an unbeatable price. Thanks, Surfshark. The central question before the U.S. Supreme Court today in U.S. versus 𝗬𝗏𝗧𝗏 is whether the Tennessee law, SB 1, which prohibits all gender-affirming medical treatments for trans minors, violates the Equal Protection Clause of the 14th Amendment. The 14th Amendment. We've talked about her a lot on this show. I made an episode all about her like a year or two ago. She is the source of many of the civil rights protections that have been hard-won and many lost over the last century. Abortion, contraception, same-sex marriage, interracial marriage, gender equality, she contains it all. If you look at the plain text of the amendment, you might be wondering, by God, it doesn't say any of that. And that's why relying solely on the plain text of the Constitution as understood by people without legal training or context to know how that text has been interpreted over the last 250 years is a bad idea. Turns out there's more to it than that, and that's by design. The framers of the Constitution openly acknowledged that it left gaps and room for interpretation because, unlike what MAGA extremists on the right think about our founding fathers, the founding fathers themselves knew they were not omnipotent and things were going to happen and change that were beyond their ability to predict. And part of the reason this very short document, the shortest constitution in modern history, has managed to stand the test of time is because it is malleable to the interpretations of the day, an idea that some of the conservatives on the Supreme Court would hotly contest, which is why, now that they're in the majority, a lot of our rights are being eroded. And the focus of much of their ire is on the 14th Amendment, which some argue has been overly stretched to include protections that were never meant to be included. These are the same people who, when faced with the same argument that the Second Amendment was never meant to include protections for AR-15s, for example, scoff at the idea that the Constitution can't be interpreted for the times. But I digress. The 14th Amendment says many things, but today we're focusing on the Equal Protection Clause in Section 1, which says, "No state shall deny to any person within its jurisdiction the equal protection of the laws." To understand the Equal Protection Clause and its jurisprudence, that is, all of the cases that have interpreted the clause, we have to talk about judicial scrutiny. Scrutiny refers to the amount of discretion judges have over blocking laws passed by the government. There are 3 levels of scrutiny. The lowest is called rational basis scrutiny, the middle is called intermediate scrutiny, and the highest level is called strict scrutiny. The vast majority of laws, if challenged on constitutionality grounds, will receive rational basis scrutiny. That is, the court will not find a law unconstitutional. They will allow the law to stand so long as the government had any conceivable rational basis for passing said law. This means the vast majority of laws will pass the constitutionality test unless the person challenging the law can prove that the government had absolutely no legitimate interest in the law or policy, or there is no reasonable rational link between that interest and the challenged law. So the courts are incredibly deferential to the government in the laws they choose to pass, which makes sense because it is the Supreme Court's job to interpret the Constitution, but if the law in question doesn't violate the Constitution, they're overstepping their bounds in blocking the law from moving forward. It's a separation of powers thing. However, under the Equal Protection Clause, the Supreme Court has determined that there are certain types of laws that require less deference and higher judicial scrutiny to determine whether they are constitutional, because the laws are impacting a certain type of protected status or class. Intermediate scrutiny applies to situations where the law being challenged discriminates based on gender or sex. So gender discrimination doesn't get the highest level of scrutiny because the Supreme Court has determined that there are certain instances where laws passed based on gender make sense. Like separate but equal bathrooms for men and women have at least historically been accepted as reasonable, where separate but equal bathrooms for whites and blacks are not, at least in the last half century. There is less of a justifiable reason why we need to separate people based on race, but there are some justifiable times when separating people based on sex makes sense. At least that's how it's always been, which is why the question about trans kids and trans bathrooms and trans sports are also hotly contested. It goes against what we have culturally understood to be normal. We've never really questioned why women and men are separated for bathrooms and sports, etc., at least not on a national level until very recently. Even so, our ears are certainly perked up if we hear a law that says men or women can't do something because of their gender. In those instances, the burden is on the government that passed the discriminatory law to prove that the law serves an important government objective and is substantially related to achieving that objective. So, for example, the Supreme Court has held that draft registration may be restricted to men only without violating the Equal Protection Clause, because in 1981, when that case was decided, women were restricted from combat service and were therefore not similarly situated to men in this scenario. The government's important objective in national security was enough to pass intermediate scrutiny. Ironically, many of the important cases behind intermediate scrutiny and the protection against gender discrimination are related to discrimination against men. For example, in 𝗬𝗪𝗧𝗛 versus Goldfarb, a case Ruth Bader Ginsburg argued before the Supreme Court when she was still an attorney, the court found that there was unconstitutional discrimination in a law that discriminated based on gender in Social Security survivors' benefits. If a husband died, the Social Security survivors' benefits automatically went to his surviving spouse, a woman. But if a wife died, the Social Security survivors' benefits did not automatically go to her surviving husband, a man, unless it could be proven that he was receiving at least half of his support from her. Ginsburg argued that it was discriminatory against female wage earners because it gave them less protection for their surviving spouse than male employees got. And she won. The court found that there was no important government objective that this discrimination substantially helped to achieve. But this is where men were receiving less money than women in this outcome. This is an example of the complex, fact-specific ways these various discrimination cases can come before the court. Okay, so that's intermediate scrutiny as it applies to the Equal Rights Amendment. And then there's strict scrutiny, which is also the name of a great podcast about the Supreme Court. Highly recommend. This is where they got their name. Strict scrutiny is the highest form of judicial review, and it is very hard for laws to pass strict scrutiny. If any law is passed that discriminates based on race, national origin, or religion, it must pass strict scrutiny in order to be deemed constitutional. Strict scrutiny requires that the government that passed the discriminatory law prove that there is a compelling state interest behind the discriminatory policy and that the law is narrowly tailored to achieve that compelling state interest. The most iconic case here is Brown versus Board of Education. In Brown, the court found that separate but equal public schools that discriminated based on race violated the Equal Protection Clause of the 14th Amendment because separate educational facilities are inherently unequal. However, in Fisher versus University of Texas, for example, the Supreme Court found in favor of affirmative action because even though it allowed for discrimination based on race, it passed strict scrutiny review because it served a compelling government interest and was narrowly tailored to achieve that interest. That, however, was overruled in 2023 by Students for Fair Admissions versus Harvard, in which the court found that, in fact, affirmative action or admission standards based on race did not pass strict scrutiny and were unconstitutional in violation of the Equal Protection Clause. This, again, came about not in the way you might think with a black person challenging discrimination based on race, but instead by Asian students challenging discrimination based on race. All of these cases and these three levels of scrutiny have laid the groundwork for the Supreme Court today as they're listening to oral arguments related to whether Tennessee is allowed to pass laws specifically aimed at barring medical care for trans youth. The Supreme Court has never heard a case like this, and while typically intermediate scrutiny is afforded to cases involving gender discrimination, this case inserts additional questions involving medical care, the ability of minors to consent to said medical care, and the complicated nature of gender identity, which weren't present in past cases involving gender-based discrimination under the Equal Protection Clause. So at oral argument, all of these things were discussed, but ultimately they are not questions for the Supreme Court to answer in this case, only for them to use in context to answer the real question before them, which is whether the ban on gender-affirming care for minors in SB 1 violates the Equal Protection Clause of the 14th Amendment. If you look at the filing history of this case, just in the Supreme Court, you will see many amicus briefs were filed. Amicus briefs are arguments filed with the court by interested parties in the case who aren't actually named parties in the case. The court can read these briefs and take them into consideration to provide more context for their decision, but they don't have to read any of them at all. And the list of amici is a veritable who's who in the fight against trans youth, from Stephen Miller's America First Legal Foundation to the Alliance Defending Freedom, which has ties to 𝗖𝗎𝗠𝗠𝗠𝗧𝗏. On the side of the Biden administration and the trans kids and their families, numerous briefs were filed by professional medical associations, groups of concerned physicians, and even Elliot Page. It's an example of just how many people have skin in the game, as it were, in the fight for or against trans youth rights. Kids, I'll remind you, children, who are just trying to live their lives and are dealing with all this shit while also dealing with just being a teen, which is hellish enough on its own. The petitioners, on behalf of trans kids and their families, argue that the Tennessee ban discriminates on the basis of gender because it applies different standards to trans youth than to cis youth, because it does not ban similarly situated cis youth from using the same medications. For example, puberty blockers are used regularly in the case of precocious puberty, which is where a kid starts puberty really early. And because this law discriminates on the basis of sex, they argue that it should be given higher scrutiny, intermediate scrutiny, in determining whether it's constitutional, which shifts the burden to Tennessee to prove that the law serves an important government objective and is substantially related to achieving the objective. At the Sixth Circuit, the court below the Supreme Court, the circuit court only applied rational basis review to the law, upholding the ban because it determined the government had a rational basis for passing the law. Like I said, most laws will pass rational basis review. By arguing in favor of elevated scrutiny, the petitioner is saying, no, this law clearly discriminates based on gender. It bars trans kids from getting treatment that is available to cis kids, and so it should be reviewed at a higher level to determine whether or not it violates the Equal Protection Clause because gender is a protected status. The brief for petitioners states, put simply, an adolescent assigned female at birth cannot receive puberty blockers or testosterone to live as a male, but an adolescent assigned male at birth can. Further, the petitioners argue that when held to the intermediate scrutiny, the Tennessee ban does not pass the test. Again, it has to serve an important government objective and be substantially related to achieving that objective. The explicit goal of the law, as stated in the law itself, is to encourage minors to appreciate their sex by prohibiting treatments that might encourage minors to become disdainful of their sex, as though it's the medical treatment that's giving them gender dysphoria. Petitioners argue this court has recognized that a statutory objective that rests on stereotypic notions about gender is itself illegitimate. It's not an important or even legitimate government purpose to want to force kids to appreciate their sex and conform to their gender at birth. Tennessee has also argued the purpose of the law is to protect the health and welfare of adolescents. Petitioners argue that this law is not substantially related to achieving this objective, saying the legislature ignored the benefits of gender-affirming care, substantially overstated the risks of that care, and adopted a categorical prohibition that is both severely over-inclusive and severely under-inclusive when viewed in light of those risks. Tennessee's invocation of health and welfare thus cannot justify its complete ban on medical treatments that offer critical benefits to adolescents and their families. They go on to say those risks were exaggerated by Tennessee's experts, can be mitigated, and in any event are comparable to the risks associated with permitted uses of these treatments and a wide range of other pediatric treatments. So the law isn't tailored to Tennessee's asserted interest of protecting the youth. It's limited only to trans youth, where cis youth also receive similar treatments or other treatments that come with risks. Puberty blockers are routinely used to treat precocious puberty, to delay puberty for patients undergoing chemotherapy, to preserve fertility for patients with hormone-sensitive cancers, and to treat endometriosis. Hormone therapy, too, is used to treat a range of conditions other than gender dysphoria, including to treat various intersex conditions, infants suffering from microcephalus, and teenage boys with delayed puberty. SB 1 allows all those uses across the board, even though many carry the same or greater risks as use of those medications to treat gender dysphoria. And there's more. Certain irreversible bariatric surgeries for weight loss are commonly performed in the pediatric age group, despite the risk of serious complications, including splenic injury, hemorrhage, intestinal leaks, and blood clots. The same is true for other medications and procedures with significant risks. Use of growth hormones to treat a minor's idiopathic short stature. Potential risks include cancer and hemorrhagic stroke. Use of anti-estrogen drugs to treat boys whose bodies overproduce breast tissue. Potential risks include blood clots. Use of mood stabilizers to treat minors with bipolar disorder. Potential risks include menstrual abnormalities, infertility, osteoporosis, obesity, and reductions in bone mineral density. Use of stimulants to treat minors with attention deficit hyperactivity disorder. Potential risks include psychosis, tics, and negative impacts on linear growth. Use of antidepressants to treat minors with depression and anxiety. Potential risks include weight gain, increased suicidality, and sexual dysfunction. Despite the risks, Tennessee leaves decisions about all of those treatments to parents, doctors, and where appropriate, the minors themselves. SB 1 singles out and bans only treatments for gender dysphoria. So the law is under-inclusive because it only bans specific drugs for only trans youth, but it also is over-inclusive because it bans all hormone treatments and puberty blockers for gender dysphoria for all trans youth under all circumstances. The law made zero effort to tailor the restriction to specific risks. Therefore, it is not substantially related to achieving the stated objective of protecting the health and welfare of adolescents. Tennessee, for its part, argues that the law does not discriminate based on sex. Transgender youth fall into both genders. It simply creates two innocent groups: minors seeking drugs for gender transition and minors seeking drugs for other medical purposes. This falls in line with the stance that trans-identifying people are just lying about their true gender. They are either male or female, and it ignores that transgender is a gender identity, and the law explicitly discriminates based on that gender identity. Again, this is not an issue that's come before the court, but inherent in this argument, the Supreme Court is going to have to determine whether transgender is a gender identity such that discrimination requires heightened scrutiny, or whether being transgender is a lie, and whatever's in your pants is your true gender, period, so the law doesn't discriminate because it includes bans against boys and girls. There is no cis or trans, there is only boy or girl. But even in that gender dichotomy, this clearly discriminates based on sex because, as I said, a person born a boy can get testosterone to live comfortably as a boy, but a person born a girl cannot. And even if the law does discriminate based on transgender status, which it doesn't, Tennessee says, even if, the Supreme Court should not get, Tennessee says, back in the fraught business of creating protected classes. It's been almost 50 years since the court recognized that someone's status should be protected based on historical discrimination. Why do that again? By adding transgenderism to the list, as though we've met our quota of protected classes and no one else can qualify. Oral argument lasted 2.5 hours today, with the conservative majority seeming inclined to agree with Tennessee and uphold the gender-affirming care ban, with Chief Justice Roberts saying, well, I don't know. Seems like a question that we should leave to the people and their representatives in the legislatures. We're not doctors here. We don't know what's safe or not. I'm just a widow Supreme Court justice. To which Ketanji Brown Jackson retorted that leaving the question to the states was an abdication of the court's responsibility to determine the constitutionality of laws challenged on equal protection grounds. There have been many instances in which the court has made determinations about laws despite not having deep background expertise in the subject area. That's literally what the briefs from the parties and the amici are for. Questions from the conservative justices are a great example of how outside forces and bias are always present, including in the opinions written by the U.S. Supreme Court. Brett Kavanaugh asked, why not trust parents rather than the state to decide? To which the petitioners responded, parents' rights are not a question before the court today. Brett also brought up trans athletes and female sports, a question not before the court today. Justice Gorsuch said literally nothing at all day. Justice Alito asserted that whether or not the medical treatment in question actually lowers the risk of trans youth suicidality isn't clearly established, despite the fact that studies have linked access to medical care for trans youth with decreased suicidality. Those studies don't definitively prove that the medications themselves are the cause. It's certainly a case of correlation versus causation. Having access to the medications also may indicate decreased socioeconomic levels and supportive parents, which could also play a role. But focusing on questioning whether or not it actually reduces suicidality in trans youth is more an indication of conservative talking points leaching into the conservative justices' decisions on this matter. And it doesn't ultimately get to the underlying question presented in the case. It's just the conservative justices blathering on using talking points they've been spoon-fed by other conservatives. Of course, oral arguments and how the justices react are like weather reports. It gives us a general sense of what's to come, but pundit predictions are often wrong, and there are many surprises that can come from the Supreme Court decisions. With the court not set to release its decision on this case until June, there is one major glaring wrinkle in this case. The petitioner in the case is the Biden administration, which intervened on behalf of the trans kids and their families. Those parties filed a separate petition to the Supreme Court to be heard, but the court only accepted the Biden administration's petition. This opens the door for Trump, once he takes the White House in January, to switch the government's official stance on the law and say that it's actually constitutional. And that'll mean that there is nothing left for the justices to decide because the federal government and Tennessee would be in agreement that the law is constitutional and should be left alone. Rather than dismissing the case outright, the court could belatedly grant the petition to the original petitioners, the trans kids and their families, and either hear new oral arguments or make a ruling based on today's arguments. But they don't have to grant that petition at all. Trump will be pretty busy doing all sorts of stuff in the first 6 months of his presidency, but given the high-profile nature of this case and the fervor with which conservatives and Trump's base hate trans people, it would be shocking for this case to fly under his radar. So odds are the Trump administration will flip, and it'll be left to the Supreme Court to decide what to do next. And I can see both scenarios. One where they're like, thank God, let's dismiss this case so we don't have to make a decision. And one where they're like, actually, hold my beer, I want to fuck up with this, so let's bring in the kids. Either way, it's an uphill battle for these trans kids today in the face of a conservative Supreme Court and an incoming conservative trifecta. If the court miraculously rules in the trans kids' favor, they'd likely do so by determining that the law does discriminate based on gender and then send it back down to the lower courts to determine whether it passes intermediate scrutiny. That could provide precedent for future challenges against other trans-related laws about bathrooms, sports, and more. If the court rules in favor of upholding the Tennessee law, that would affirm the other laws across the country that similarly ban care for trans kids and would provide opposite precedent in support of other trans-related laws about bathrooms, sports, and more. In offering some perspective, Chase Strangio, the attorney who argued on behalf of the kids and families, acknowledged it would be an uphill battle at a press conference yesterday, but pointed to the court's 1986 decision upholding bans on gay sex, which was a bleak moment, but 17 years later was overruled when the Supreme Court found that laws banning gay sex were in fact unconstitutional. 17 years. And while it may be easy to focus on that number and say, holy shit, we're doomed, it's so slow, I will say that that is the name of the game with constitutional law and civil rights activism. It's not a couple protests, a quick court case, and things are fixed. It's court case after court case, and those things each take a long time, setbacks, backlash, and years of work for just inches of progress. It can be overwhelming, but I find some solace in knowing that generations of people, lawyers, activists, have been working on this shit, and there is more work to do, but we each play a small role. It's not about one person saving the world, it's about not giving up. And I'm not a patient person, but I'm certainly stubborn as hell. So that's what I'm bringing to the table. Support the trans folks and especially trans kids in your life. Speak out against discriminatory bills to your lawmakers. Keep educating yourself and give to orgs like the Trevor Project that has many initiatives to support the trans community. Court cases are only one avenue of activism, and there is so much more we can do in the meantime to bend the arc of the moral universe towards justice while the court catches up. If you're interested in learning more, I invite you to join me over on Patreon, where we're planning some initiatives to help build community in Trump's America. Plus, you get ad-free and uncensored versions of these videos as well. Go to patreon.com/Leeja Miller to join. Thank you to my multi-platinum patrons, Art, David, RHT, Latranger Lucas, Joshua Cole, Thomas Johnson, Anthony Giles Tay, and Brett Piontek. Your generosity makes this channel what it is, so thank you. If you like this video, you'll like the one I made about why conservatives are so obsessed with trans kids. Thanks so much for watching. Have a good day. Bye-bye.